Well, let's take a closer look at quarantine now. In the next week or so, over 150 South Africans will be returning from the epicentre of the coronavirus in China. They will be placed in a secure location and in quarantine for at least 21 days. Well, does bringing these citizens back to the country put the rest of us at risk? What does the law say about quarantine? I'm joined now by constitutional law expert, Professor Michael Osborne from our Cape Town studio. Professor, thank you so much for joining us this morning. Ethically, am I correct that there's a situation of competing rights, the individual's right to personal liberty versus the community right to safety and proper disease control?
Good morning. Yes, that's quite right. The Constitution in Section 12 envisages or provides that there's a right not to be detained arbitrarily or without trial. But that right is always subject to limitation under Section 36 of the Constitution, which provides that in appropriate circumstances where the public interest is gravely implicated, there can indeed be exceptional cases of effectively involuntary detention in a circumstance precisely like this.
So am I right that if someone, let's say someone comes back from South Africa and says, no, I am fine, I've been tested for the last 6 weeks, there's nothing wrong with me, I refuse this quarantine, legally they simply have to be there? They are essentially, as you say, detained under special circumstances.
That's right. Regulations have been in place for a while now, made by the Minister under the National Health Act, which anticipate the situation we now face. Those regulations provide for the establishment of quarantine centres. The right is given to the use of force, if necessary, to detain those who do not wish to be detained. The situation is the Director General of the Department of Health has got to make the appropriate ad hoc regulation, and the detention will be subject to that ad hoc regulation. What must be emphasized, however, is there's always a possibility of a constitutional challenge. If, for example, someone who's detained asserts that their detention is arbitrary or unreasonable, they may go to a court at any time and say that their fundamental constitutional rights are being infringed. And the way they'd do that is they'd say, well, yes, indeed, we acknowledge that there is a countervailing community interests, one might say, but they would say that the particular regime under which they are being held is unreasonable or arbitrary or disproportionate. And one would think of, for example, excessively extended periods of detention, or of the detention of persons who were, or who could demonstrate that they'd not been anywhere near an infected area. So, as always, you're going to have the possibility of challenging a particular detention on a circumstantial basis.
Sure.
By demanding that the government provide objective and reasonable bases for that detention.
Could we see a challenge coming from a different angle, a member of the South African public saying, I don't want these South Africans who've been at the epicentre of this virus outbreak back in the country? We have heard that some people returning under quarantine have actually spread the virus in their own country. Would there be legal grounds for challenging that constitutionally?
I think the grounds there would be much, much weaker. There's perhaps one of the most fundamental rights in the Constitution is not to be detained. There's no particular right not to have, for example, a centre in one's neighbourhood. There's no particular right to say that I demand not to be in proximity to someone who's recently been to China. So, yes, indeed, there's a right to health, but it would be most unusual for anyone to be able to assert that right in the circumstance that you are suggesting.
Thank you.